Good morning, everyone. I'd like to thank you very much for coming over to today's webinar. The subject today is rentals, handled with care. In the course of our real estate career, we encounter many people who are interested in doing rentals with us. Sometimes they are landlords, sometimes they are tenants. And it is extremely important for us to do rentals correctly, because although we make the rental commission much faster than any other type of commission, rentals carry a lot of different requirements. And if not done correctly, we could end up with a problem. And that is one of the things that we are hoping to avoid with this seminar. We are going to start today's seminar with a quick little
Hi,
video
I'm Wayne. Are
to
you
show
here for
us
the
how
closing?
not to get in
No.
trouble.
I'm here to consult the attorney about an unfortunate situation with my landlord and real estate agent. I rented a property and it is falling apart. The landlord is not answering my calls and my agent has been unable to provide the help I need. I've just decided to sue everybody.
One of the problems that we have with rentals is that sometimes a rental situation lasts a long time. We find a tenant, we put them in the apartment, and that tenant is there for sometimes a one-year lease, sometimes longer. During that time frame, if there is a problem between the landlord and the tenant, they will inevitably drag us into it. It will, in most cases, become a problem for us in the future. In order for us to avoid an unfortunate and unhappy situation like what happened in this particular example, we need to be aware of a few different laws. Now, this is a short webinar, which is not going to be able to cover everything, but I will try to cover as many of the requirements that we have as possible. We need to be aware that the truth in renting requirements falls on the landlord. However, when we take a listing for rent, whether it is an oral agreement or a written agreement, we become responsible for the landlord's obligations. One of those obligations is to provide to any tenant at the time that the lease is written, the Truth in Renting booklet. Now, there is an updated version from 2010, which includes some changes in the law that are not found in some of the booklets that I have seen come around, which are from 2007. We need to be aware there's an updated booklet. Now, the landlord is required to keep documentation or receipt verifying the distribution of the booklet to the new tenant. When we are representing the landlord, then we take on that responsibility of the landlord. It becomes our responsibility. Now, how do you keep verification that you provided the booklet? You may have provided it to the tenant, and the tenant lost it or didn't read it. And then 6-8 months later, sometimes a year later, they may forget that you provided the booklet. Now, if you have something in writing that says that they've received it, there you have your proof. Otherwise, you are depending on their memory. And if they're upset, they are not going to remember many of the things that you provided to them. Another thing to remember is that the Truth in Renting requirement applies to dwelling units, which includes apartments, houses, rooms, or mobile homes or mobile spaces for any rental term of at least 1 month. This does not apply to renting an apartment down the shore for a week, but anything that is longer than a month, it requires it. Now, in the truth in renting, it includes the requirements that landlords have, as well as the obligations of both landlord and tenant. It also includes a walkthrough. It talks about the landlord and the tenant having a walkthrough of the property and documenting if there's any damage or repairs that need to be made at the beginning of the lease as well as at the end of the lease. Now, there are many different forms that can be used, but again, it becomes our obligation to make sure what is the condition of the property when we handed the keys to the tenant. Also, it includes what happens with a renewal or breaking of a lease. It includes the eviction requirements. It also includes termination of the lease and proper notice. Based on specifically the new version includes if there's a disabling illness, accident or death, domestic violence. This is found in the new version and it's not in the 2007 version, as well as military service and any displacement by flood or any other natural disaster. The booklet is pretty lengthy, and it is our responsibility to read it and know what's in it because we are responsible for providing it and knowing what it has. Now, the next item of danger in rentals is lead. Not just lead paint, but lead hazards in general. Now, the lead disclosure rule, which was passed by Congress, applies to every property for sale as well as for rent of a property that was built before 1978. It requires initials from the landlord on the top and the signature as well as the date, which has to be the same date as the date of the listing. And then it requires the listing agent to sign it. And it also requires the initials of the tenant verifying or confirming that they have received the lead booklet. The lead booklet that we have to provide to them. Now, it also requires the renting agent or the agent that was working with the tenant to sign the form. And so many times we see forms that are either not initialed or not signed, or they don't have the correct date. Any improperly filled out lead addendum that is found in a file can be potential, can have potential consequences that may be very expensive. The housing that is covered is most private housing, public housing, as well as federally owned housing and any housing receiving federal assistance. Now, record keeping, it is required that the lessor or landlord, as well as their representative, retain a copy of the disclosure. According to this federal law, it is for no less than 3 years. However, as licensees of the state of New Jersey or Pennsylvania, we have to follow the requirements of our documents. And for us in New Jersey, it is for 6 years. Now, let's talk a little bit about this lead addendum, okay? There are some exemptions. The exemptions will not, or the requirement of the lead paint does not apply for buildings or properties where the common areas have been certified to be lead-free, or the interior of the property has been certified lead-free. Now, if the interior has been certified lead-free, that does not exempt the entire building, unless the entire building, inside and out, has been certified lead-free. Now, what is certified lead-free? That means that a licensed, approved lead abatement company has come in and removed and disposed of all of the lead found in the property. And when that is done, they will provide a report. That report states the property is lead-free, even though it was built prior to 1978. Now, a lot of investors are buying older houses, remodeled the houses, they gut the whole house, they go all the way to the studs, and they put new siding on the exterior, and they put brand new walls, and then they claim that the property is lead-free. That does not follow the New Jersey law, specifically in New Jersey for lead abatement. Okay, if the property, the foundation was built prior to 1978, even if they gutted the house, unless they have the proper paperwork for abatement, you still need a lead addendum. All they have to do is put no records, no reports, and provide the form. Okay? It is very important to have that. Otherwise, you are in violation of these federal laws. Now, another property that is exempt from the lead paint requirement is a seasonal rental for 6 months or less than 6 months, or an owner-occupied unit. So if an owner is renting a room in their own home and they live there and they're only renting one room, then they do not have to provide the lead paint. But in most cases, when we are involved in a real estate transaction and a rental, and the property was built prior to 1978, we need to make sure that we have the proper forms correctly filled out and completed in our files. A violation of the lead law can have fines of up to $11,000. So that is not something most people have money laying around to give out, and that's for each violation. Now let's move on to discrimination. In the New Jersey laws against discrimination, we are required to provide equal treatment in sale as well as rental of housing based on race, creed, color, national origin, ancestry, sex, marital status, civil union status, domestic partnership status, familial status, affectional or sexual orientation, gender identity or expression, mental and physical disability, nationality, or source of lawful income. Now, in the state of Pennsylvania, because we do have agents in Pennsylvania, the law is called the Pennsylvania Human Relations Commission, and it applies to housing as well as commercial property. In New Jersey, it applies only to residential property, not commercial. In Pennsylvania, it applies to residential as well as commercial. And it includes more or different categories than it does in New Jersey. So any agent who is licensed in both New Jersey and Pennsylvania has to be aware of both laws. In Pennsylvania, it specifically prohibits discrimination based on race, color, sex, religion, national origin, ancestry, age, which is not included in New Jersey, for 40 and over, based on pregnancy, which is not included in New Jersey, familial status, handicap or disability, the use of a guide or support animal due to blindness, deafness, or physical disability, or because the user is a handler or trainer of these animals. And also disability of an individual with whom the person is known to have a relationship or association. So we have the New Jersey law, the Pennsylvania law, and for some people who are licensed in both, you need to be aware of both. Now, when it comes to exemptions, the exemptions from the anti-discrimination laws apply to landlords, or the law applies to landlords and tenants, but the exemptions involve two-family owner-occupied dwelling, rooms in an owner or resident-occupied single-family home. Now, this statement causes a lot of confusion for a lot of real estate agents, because according to this, the owner would be able to choose who they live with or who they rent to if it's a two-family house. However, the exemption is lost if the owner hires a real estate company or agent to represent them. This only applies if the owner on their own, like a rent-by-owner, without using discriminatory advertising, rents directly to the tenant. The moment we as real estate agents are involved, that exemption is lost. Lost. Let me repeat that. Lost. They cannot use that. Now, there's another exemption, which is for property exclusively planned or occupied by one sex. For example, renting at the YMCA. We're usually not involved in those. Or age-restricted housing as it pertains to familial status for those 55 and older communities. Any of those communities, they have restrictions. So grandchildren and children who are not of age are not allowed or supposed to be moving in with grandma and grandpa. That's the reason they made them that way, so that children could legally be excluded, or people who are not of that particular age category. Now, a landlord is allowed to not accept people or a family based on illegal overcrowding. If it's a two-bedroom apartment and there are 8 people in the family, that's illegal overcrowding. Or if the occupancy violates the legal occupancy limits of that particular town, and every town has different requirements. Now, another way of saying, no, you cannot rent here would be if the individual has poor credit or they do not have enough income to afford the apartment. Other than that, the apartment has to be made available. Now, in the Attorney General's memorandum, there's a note that says the first 2 exceptions, that was the one that we just covered before, the one that says two-family owner-occupied dwelling or a single-family property. I'm going to go back to that. It says the first 2 exceptions, those 2 I just mentioned, do not apply if the dwelling was built or substantially rebuilt with the use of public funds, or if it was financed in whole or in part with a loan that is insured or guaranteed by the federal government. That includes if the property was purchased or refinanced with the FHA program or VA program or any of the Department of Agriculture, like in the rural areas, then that even if the homeowner wanted to rent themselves, they would not be able to discriminate, period. Now, most people don't go back and realize that when they purchased the property in 1943, that they purchased it with the FHA program. That means that they would not be able to. Now, this, even if there is an exemption that is allowed, this may not be allowed if the reason is based on race, because that would be covered under the Federal Civil Rights Act of 1866, which forbids any type of discrimination based on race. Now, as brokers and salespeople, we are licensed, some of us by the New Jersey Real Estate Commission, some of you by the Pennsylvania or by the New York Real Estate Commission, some of you by both, okay? Our activities are subject to the laws of the state, and every single state that I have ever researched has their own rules and regulations prohibiting discrimination of any type. That is why when a homeowner hires us They lose any exemptions that they would have had if they rented on their own. We, as real estate licensees, have absolutely no exception. And not following that could cause us to lose our license, to have to pay monetary damages, and a whole bunch of other problems. Now, in New Jersey, we are required to provide the Attorney General's Memorandum on Discrimination to every seller and landlord at the time that we provide our services and take a listing. In Pennsylvania, it is called the Responsibilities of Owner of Real Property under the Pennsylvania Human Relations Act. And it instructs us that if we have a homeowner, a landlord, who intends to discriminate or gives us any inclination of discrimination, that we are required to refuse the listing based on any of the criteria or the protected classes. It is also very good practice for us to use the Equal Housing Opportunity logo in everything we do. It is not required by law, and a lot of people call me and ask me all the time, do I have to put it in? No, you do not by law have to put it in. However, not using it may be seen in the case of an investigation as a disregard for the law, and that could become part of the allegation that that you're not following the requirements and the laws. So it's best to use it. Now, with the Attorney General's memorandum in New Jersey specifically, because I tried to find the details for Pennsylvania and New York and I was unable to find it, but in New Jersey specifically, anyone who is found in violation of the law against discrimination, the penalty for the first violation is up to $10,000, up to $25,000 for a second within 5 years, and up to $50,000 for 2 or more in the last 7 years. So this is not money most people have in their pocket just to, give out because they were found guilty. In addition to these fines, we could also lose our license. So it's very, very important for us to be very, very careful with situations like that. Now I want to move on a little bit to the use of credit reports or consumer reports that a lot of landlords, most landlords, want to know who they are renting to. The Federal Trade Commission is the one that regulates the use of reports or consumer reports. And we need to be aware. This is a booklet that is provided through the Federal Trade Commission website, and it is specifically for landlords. Now, when we represent the landlord, then it becomes our obligation to know what the landlord's obligations are. Now, a landlord is allowed to ask for a consumer report, which provides credit scores or credit ratings or anything like that. However, when a landlord is not choosing a tenant, let's say you have 4 different applicants and there's only one apartment or house. Well, one person is going to be accepted and 3 are not. We need to be aware that the 3 people who will not be accepted into that apartment, the landlord is required by law to provide an adverse action notice, which is taken, it could be solely or partly based on the consumer report. We are required to provide the name, the address, and the phone number of the company that supplied the consumer report, including a toll-free telephone number. We are required to keep that in our file. The notice also has to include the individual's right to dispute the accuracy of that information in the consumer report. In addition to that, it includes that the credit report or the consumer report did not make the decision to accept or reject a tenant. So this has to be included in that adverse letter. We also need to be aware that credit report may be used for identity theft and for fraud. And when we request copies of them, or we keep them around, or we keep them in our car, or we keep them in our office, we are responsible for that. Once the apartment has been rented, we are required to shred those documents and dispose of them immediately. The landlord also is responsible for that because it could cause a problem. Now, one more thing I want to discuss in this webinar is tenants in foreclosed property. If you get the listing for sale for a property that is occupied by a tenant, there is a letter that went out from the New Jersey Real Estate Commission a couple of years ago, specifically stating that if a tenant has not violated the lease, they cannot be evicted or asked to move out solely on the grounds of foreclosure. Okay, so for a listing agent who wants to sell a property and there's a tenant there are different ways to deal with those tenants, but asking them to move out or sending them letters basically saying the property has been foreclosed, I am in charge of selling the property, you have to move out, that is a violation that can get you in trouble with the Real Estate Commission. And again, there's a lot of information, but in the time frame we have today is not enough. Now, let's talk about security deposit. When you're working with tenants and the landlord requests a security deposit, the landlord may choose up to the maximum allowed by law. In New Jersey is 1.5 months of the rental amount, not more. If they have a pet and they want additional security deposit because of the pet, that is not allowed no matter what you call it. Okay, the amount allowed by law for the landlord is 1.5 months. So they may charge 1 month for the people and half a month for the pet. That would equal 1.5 months. But they would not be allowed to ask for 1.5 months for the people and another month for the pet, because that would exceed the 1.5 months allowed by law. This also applies to additional people. So if the apartment is rented to 3 people and they get another person, a roommate that comes in, the landlord cannot ask for additional deposits. They can ask for additional rent and then the equivalent of 1.5 months of that additional rent, but not additional deposit that would exceed 1.5 months. Now, the deposit of that money has to be made into a separate account. If it's an individual, the deposit has to be made within 1 month, and the tenant has to be notified where is the bank, the name of the bank, the account number, and the type of account it is. Now, if the landlord owns or is receiving deposits for 10 or more rental units, the money has to be invested differently. It has to be placed into an investment account, which is insured, either an insured money market account or an investment account with variable rate of interest. In any case, whether it is 1 apartment security deposit or 10 or 50, the money may not be mixed with the personal money or property of the landlord. It does not belong to the landlord, but to the tenant always. we need to be aware that at the time that we are taking the deposit, most of the times when we're taking the deposit, we have to provide the 1099 form so that the landlord will be able to open the account in the bank. Now, when every year the landlord is responsible of sending notification to the tenants of where their money is located, and any interest that has been accumulating over the year has to be, if it exceeds 1.5 months, it has to be provided to the tenant either in cash or credited toward the payment of the following month's rent, or at the anniversary of the lease, or another option is always on January 31st. Now, we don't get involved in that at the end, but we do need to notify the landlords of what their requirements are. Now, if the property is sold, then, or the property is conveyed and sold to another individual, then the security deposit gets transferred. But the owner is required, according to, and this is found specifically in that Truth in Renting form booklet, it is found that the landlord is required to provide a notice to the former tenant within 5 days of the date of the closing, letting them know who is the new owner of the property. Okay, another thing is that in the past, at least in New Jersey, there were administrative and service fees that were allowed, and they are not allowed anymore in New Jersey. Now, any exceptions to the security deposit is only for rentals that are weekly rentals, for example, that are for the shore, you know, the beach rentals or anything like that. That's the only exception. Now, the return of the security deposit has to be made after the termination of the lease, and the landlord is required to provide that money back within 30 days. Now, the tenant is not allowed to use the security deposit for rent. But sometimes the tenants want to do that the last month. Well, it's in the lease. It should be in the lease, and it's in the Truth in Renting form. There is another situation, which is if the tenant has to move out due to domestic violence. This is one of the amendments that is found in the new booklet. If the tenant has to terminate the lease because continuing to live in that apartment causes imminent threat or physical threat or harm to themselves or to their children, they are entitled to have the security deposit returned. They are actually allowed to break the lease in that situation. Now, if the displacement is due to fire, flood, condemnation, or evacuation, there are also requirements that the landlord has with the security deposit and the portion of the interest that has to be returned to them if the property cannot be occupied. Now, if the property was rented or there's assistance from a government agency such as welfare, Section 8, or any other rental assistance, the law may impose or the government may impose civil penalties against the landlord who has intentionally and willfully withheld the deposit, and that is something that is also included in that Truth in Renting booklet. So I would encourage all of you to grab a copy of it and actually read it. Understand what's in it. And when you're giving it to a landlord or a tenant, please get verification that they received it. Okay, now, working with tenants. This is just a quick situation of someone who formerly licensed salesperson. That means that their license was taken away specifically because this person failed to turn over a rental payment and security deposit to his broker, and also failed to promote and protect the interests of the client. The salesperson not only lost the license, it was revoked, but also incurred a fine. Another situation that we want to be aware of is that when we're working with tenants, now I know tenants are quick. Rentals are quick and easy money. However, we need to be aware, according to the New Jersey license law, and this is taken specifically from there, every person engaged in the business of referring for a fee prospective residential tenants to possible rental units not only has to be licensed by the New Jersey Real Estate Commission, but also has to comply with these provisions. And then it says, every licensee subject to this section shall enter into a written contract with the prospective tenant and give such a person a copy of the contract. The contract shall accurately state the services to be performed, the fees to be charged, the date and the duration of the contract, the affirmative actions required of the prospective tenant in order to utilize the service, a refund policy, and also a statement that the business is licensed by the New Jersey Real Estate Commission. This is, in essence, it's kind of like a listing agreement for the tenant, or an agreement that they're going to rent with us. In the same law, it also includes that no licensee shall advertise or refer to as prospective residential tenants any non-existent address, a property that was not verified. But number 3 and specifically D are very important. A possible rental unit for which the licensee does not have the lessor's oral or written consent to refer prospective tenants. Now, we need to have authorization in writing. If we receive oral consent, that's where the landlord says, you know what, I don't want to list with the property, just bring me tenants if you find somebody. That oral consent shall be confirmed by the licensee in writing within 24 hours of the licensee's receipt of such consent. That is, in essence, an open listing. But in order for it to be valid, we need to have that oral consent turned into a written consent by sending the landlord a memo. It can be by handwritten memo or by email that says, Mr. and Mrs. Landlord, you are authorizing me and Realty Executives to rent your property or find tenants for you. And that's basically turning an oral agreement into a written agreement, but it has to be provided. Now, it is also very important, if we do get a listing agreement, to get signatures on the listing agreement, not just for one of the individuals who owns the property, but for all the individuals that own the property. See, if you receive the oral consent and you're sending the verification that they gave you this authorization, it doesn't have to be signed. You just need to make sure that they receive it. But if you do get a listing agreement, here's a situation where a licensed broker admitted that they failed to obtain the signature of the co-owner of the property prior to listing the property. So the property was owned by two people, and there was only one signature on the listing agreement. That is a violation. In addition, the law also states that licensees' obligations to obtain written confirmation of the intentions of, this is getting the intention in writing, getting the authorization in writing for promoting the property, but also to deliver copies of the documents to the parties in the real estate transaction. In the case law, there is a situation that says that there was a lawsuit in 2001, and it specifically states that the responsibility is on the agent or broker to deliver any fully executed contracts to all of the parties. That includes for sale as well as for rent. And then on leases prepared by licensees for a term of 1 year or more, there is attorney review. And even sometimes what happens is at the end of the month, you get on a Friday someone who's desperately looking or searching for an apartment, and they want to take possession on Sunday. Well, they do have attorney review period allowed to them. That's both for the landlord and the tenant. Now, if they choose not to use an attorney, that's fine. But we need to be aware that attorney review is still valid, and it is still something that they have a right to. So sometimes when those rush situations at the end of the month, sometimes over a weekend, and we're handing keys over to people, if they change their mind, or the landlord changes their mind within the 3 days of attorney review, but the landlord has already authorized you, or maybe not authorized you, to give the keys, but you handed over the keys, there's a problem right there that can happen. How these things may be avoided is by very specifically talking to the landlord and to the tenant up front at the beginning of the transaction, explaining what you have to do, what you are not allowed to do. Now, when working with landlords and tenants, it's very important to include the declaration of the business relationship. Are you specifically working with the landlord or with the tenant? If you're a dual agent, you have to provide in writing the authorization from both. You have to obtain it from both. And any rental commission must always, always be paid by the broker. Sometimes I have seen some situations where people get in trouble because the tenant provided $1,000 commission in cash. So the agent sends over to the office $500 because that's the amount that goes to the broker. Well, that right there is a violation because the cash rental in its entirety has to go to the broker. It has to be documented through the transaction, and it has to be included in the commission that the broker has to write a check back to the agent. It's much easier to take cash. Well, yeah, that would be great, but that's a violation. Now, all the parties in that rental must receive a completed duplicate copy of all the documents that were signed at the time of the listing, but also at the time of the rental. And sometimes we get documents that are signed by the tenant, but they were not signed by the landlord. And that right there is a problem that could come back in the future. Maybe during the transaction or during the year or 2 years later, the tenant becomes unhappy or the landlord wants to get rid of the tenant. And now they lost their copy of the lease. Of course, they're going to come to us and say, well, would you mind giving me a copy of the lease? Well, if you don't have a fully executed copy of the lease, you've got a problem. Now, the security deposits, we have to be aware of handling them properly. And then also, One more thing that I see a lot of problems with is disclosure. If it's your property, you own the property, you're the landlord and the agent, you are required to disclose in the lease that you are the landlord. Well, it gets disclosed at the time when you list the property, but also when you are the landlord, it has to go in the lease that the landlord is a licensed real estate agent or salesperson or broker. But also if you are the tenant, if you are renting a property to live in, then you also have to include the disclosure in the lease. There is an individual, a salesperson who was found in violation for accepting a commission in advance from an entity other than her employee broker and ended up with a fine. Now, what happened was the tenant provided the fee in advance, and the agent never gave the money to the broker. Here's another one where the broker and the last salesperson ended up with the fine for failing to ensure that a proposed lease was properly completed. There were items in the lease that were missing, that were not filled out. Also, failing to declare the agency relationship. We both agreed and held jointly and severally responsible to pay restitution to the client, and they both were required to take a 30-hour broker pre-licensing education course, which does not count for CE. Situation where the commission found the broker returned a security deposit to a tenant without the landlord's authorization. Also taking a listing and preparing a lease in the name of one owner, where in fact there were 3 owners of the property. And also failure to put rent or security deposit in the escrow account, which was also a violation. So sometimes one situation can end up with several violations. Now, there's a situation which happened in Passaic County a few years ago. The broker and the salesperson, who also happened to have a broker's license, this individual did not specify the termination date on a listing agreement. And also the broker got in trouble because when they found out, it turns out that she did not have the authorization of the landlord. So directing or allowing the broker salesperson to list a property without consent from all of the owners involved. The broker failed to supervise the activities of the broker salesperson in handling the transaction. They both ended up having to pay fines. And lastly, this is the last one I'm going to go over. When a formerly licensed salesperson failed to notify the broker that he entered into lease transactions as a property manager and represented that he would be collecting future rent instead of directing the funds to his broker or the property owner. This demonstrates incompetence. And he also failed to indicate his business relationship to the seller in a listing agreement. The real estate license was revoked and had to pay a fine. So obviously there are a lot of different laws that we have to deal with. There are a lot of requirements. Yes, rentals are quick, they are easy, but they are dangerous if they are not handled correctly. I hope that this has been helpful for you. There is a lot more. It's impossible to cover in such a short time. So if you have any questions, I am sure your manager or myself would be happy to help you. If there are any forms that you need, they are all found in our fillable documents. And if there's anything that we need that we don't have, I'm sure we can get it. I really appreciate you coming to today, and please check us out on Thursday, where I will be covering the farming portion of the webinar. Thank you so much, and I wish you lots of success in your business. Have a great day. Bye-bye.